and I have the honor to be with you throughout this session in this morning. Dear all, BIAC is the first and only licensed and registered alternative dispute resolution institution facilitating resolution of domestic and international commercial disputes through arbitration and mediation in Bangladesh. BIAC started its operation since April 2011. BIAC has developed all the facilities required for systematic and comfortable arbitration and mediation proceedings. BIAC has its own arbitration and mediation rules. Apart from facilitating arbitration and mediation, BIAC also provides training courses on ADR, especially arbitration, mediation, and negotiation, to develop a pool of human resource in this field. Since inception, BIAC has been working hard to create awareness about ADR methods by conducting several outreach programs, seminars, workshops, dialogues, and webinars. BIAC had launched an inter-university arbitration contest in 2020 for students of law of Bangladeshi universities. In 2021, the contest was more broad-based with participation by universities beyond the borders of Bangladesh with the generous patronage of the Citibank Limited. The contest aims to acclimatize the participants with the theoretical and practical knowledge of the arbitration process and groom them to be better equipped legal professionals in the future. This year, BIAC is hosting the Citibank BIAC International Inter-University Arbitration Contest for the third consecutive year. As in the past, the contest will be conducted online. However, the final will be held in person. This year, 8 leading universities from home and abroad are taking part in this contest, which are last year's champion, University of Dhaka, Bangladesh, the London College of Legal Studies, LCLS South, Bangladesh, Kathmandu University School of Law, Nepal, Bhuyan Academy, Bangladesh, North-South University, Bangladesh, University of Barishal, Bangladesh, Newcastle Law Academy, West Bangladesh, Bahria University, Islamabad, Pakistan. In each round, every team will consist of 4 to 6 students from each university. Each team will be comprised of students with the roles of coordinator, counsels, and witnesses for their respective sides. 60 minutes have been allocated for each team to present their cases. First session of the preliminary round of this contest was held on last Saturday, 12 November 2022, where Kathmandu University School of Law, Nepal, won the session against London College of Legal Studies South. Now we are in the second session of preliminary round, where Bhuyan Academy Bangladesh is competing as claimant against the team of North-South University Bangladesh as respondent. Before we move on to the main contest, it is my pleasure to introduce the 6 participants from Bhuyan Academy and North-South University. Representing Bhuyan Academy team, Sumaya Binte Yusuf, Tamzid Tashfi, Aryan Fardin, Maisha Fahmida Sharkar, and Khandokar Sadiq Naib. Representing North-South University team, Farzana Zareen Mira, Sumaya Tabassum Faiza, MD Abdullah, Wasi Pervert Tasin, Imritat Hossein Elma, and Saad A. Toki Khan. At the start of the contest, please state your respective roles to the arbitrator. Both teams have already submitted their submissions to the arbitrator of the session and other party. And we have already circulated the program of the session. I'd like to request our today's arbitrator, Mr. Rana Sajjad Ahmed, to strictly follow the time slots that is mentioned in the program. This is to ensure that both parties get equal opportunities. Now, I would like to start the event by introducing our Chief Executive Officer of BIAC, Mr. Kaiser A. Chaudhary. Mr. Kaiser A. Chaudhary joined Bangladesh International Arbitration Center on 1st February 2022 as its Chief Executive Officer. Mr. Chaudhary holds a master's degree in economics from the University of Dhaka and is a professional banker, having started his career with Greenlace Bank in 1975. He held several senior positions in the banking industry, including the positions of Deputy Managing Director and Managing Director of the country's 3 commercial banks, and also officiated as the principal of Training Institute of Dhaka Bank Limited. Currently, he is in the board of Premier Bank Limited as its independent director. Now I request Mr. Chaudhary to deliver his welcome address.
Thank you, Priyanka. Thank you so much. Much respected Mr. Rana Sajjad, arbitrator of today's session. Distinguished guests and dear participants from BIAC Academy, Bangladesh, and the North-South University, Bangladesh. Good morning to you all. It is indeed a great pleasure for me to welcome you all to the Citibank BIAC International Inter-University Arbitration Contest 2022. It is also my privilege to reiterate our gratitude to the Citibank Limited for sponsoring this important event of BIAC. It is a matter of great pride for BIAC that it is hosting the annual Citibank BIAC International Inter-University Arbitration Contest for the 3rd consecutive year for university level students, with an aim to acclimatize the participants with the theoretical and practical knowledge of the arbitration process to groom and shape them into better equipped legal professionals. Moreover, in course of this contest, students will get an opportunity to acquire practical knowledge of alternative dispute resolution and develop necessary rhetorical skills, and furthermore, stand to benefit through the delivery of advisory notes by top regional and global professionals in the field of ADR. In 2020, BIAC launched an inter-university arbitration contest for the first time for law department students of the universities in Bangladesh, which was organized online in the wake of COVID-19. In 2021, BIAC arranged a more broad-based international contest with online participation by students of 7 national and international universities. The event was aptly titled as the Citibank BIAC International Inter-University Arbitration Contest 2021, being held under the generous sponsorship of the Citibank Limited. The contest, first of its kind in Bangladesh, was held in digital platform in the last quarter of 2021. A few words about BIAC. Bangladesh International Arbitration Center, or BIAC as we know, is the first arbitration institution of the country. It is registered as a not-for-profit organization and commenced operations in April 2011 under a license of the government of Bangladesh. The International Chamber of Commerce, Bangladesh, the World Business Organization, Dhaka Chamber of Commerce and Industry, and Metropolitan Chamber of Commerce and Industry, Dhaka, are the sponsors of BIAC. International Finance Corporation, IFC, the private sector arm of the World Bank, with funds from UK aid and European Union, had supported BIAC during its initial stages under a cooperation agreement. BIAC provides a neutral, efficient, and reliable dispute resolution service in this emerging hub of South Asia's industrial and commercial activity. BIAC aims to embed the use of ADR as a commercial best practice to facilitate creation of an ecosystem that fosters investment and is conducive to business. BIAC is committed to be a credible and a sustainable national institution that aims to offer international commercial best practices on ADR services to individuals and institutions seeking to resolve commercial disputes. Since its inception in 2011, BIAC has received the recognition of 62 national and international institutions, including the Permanent Court of Arbitration, The Hague, the Netherlands, and many other international ADR centers, local corporate companies, financial institutions, real estate companies, NGOs, universities, and law firms in Bangladesh. Membership. BIAC offers membership to practitioners, stakeholders, students, and interested individuals at home and abroad to create a knowledge and resource sharing platform. About outreach programs, BIAC has since organized 155 workshops, seminars, and webinars till the present time. Although COVID-19 has frustrated holding of many of its events, BIAC hosted a number of webinars jointly with its local and regional partners. BIAC also organized a national consultation session based on the request of the Law Commission Bangladesh on proposed Arbitration Amendment Act 2018 by Law Commission Bangladesh, and the recommendations from the session on the proposed Arbitration Amendment Act 2018 was sent to the Commission. We have proposed to the University Grant Commission and the Bangladesh Bar Council to include ADR in the academic curriculum in order to raise awareness and popularize this alternative dispute resolution procedure within the country. UK Foreign and Commonwealth Office recognized the role of BIAC in their publication, Bangladesh Doing Business Guide. This guide is for British businesses who are interested in developing their overseas trade in Bangladesh. US Embassy also recognizes BIAC as a forum for resolution of US disputes and have enlisted BIAC in the process. Once again, our sincere appreciation for the generous support and contribution of the Citibank Limited, as well as the continued enthusiasm of the academia and the students to participate in the contest and making it a successful one. Thank you all, and best wishes to the participants. Thank you.
Thank you, sir, for delivering your welcome address. May I now introduce our today's chairman of the session. We are extremely honored to have with us Mr. Rana Sajjad Ahmed, who is the founder and president of the Center for International Investment and Commercial Arbitration, Pakistan, and partner of Rana Sajjad and Partners, Lahore. Mr. Sajjad is a practicing lawyer in Pakistan and USA in areas including contracts, cross-border transactions, commercial litigation, and domestic and international arbitration. He is a fellow of the Chartered Institute of Arbitrators, CIARB, UK, and an accredited mediator of Singapore International Mediation Institute, SIMI. Now it is the time to start the contest and accept the participants and the arbitrators. Sorry for the inconvenience. Now I'd like to hand over the platform to our arbitrator of the session. Best of luck to both the teams.
Thank you. Good morning, everybody. Thank you all for attending the hearing today. I understand we have representatives of both the claimants and respondents. I also understand there are two witnesses who are attending this hearing today. In terms of the proceedings, as you're all aware, both parties have 60 minutes for your submissions and cross-examination. but it will actually be broken down into 3 sessions. So we'll have a 50-minute session first for claimants, whereby they'll submit their oral arguments and their witnesses will be examined. And then we have another 50-minute session in which the respondents will submit the oral arguments and their witnesses will be examined. And in the end, we'll have 10 minutes each for both parties to submit their closing statements. I would urge the parties to abide by the time frames and do not exceed their time limits. In terms of keeping time, it would be helpful if somebody at BIAC could do it. If not, then I don't have a choice. I'll have to do it. I was wondering, Priyanka, if you or anybody else could keep time, or do I have to keep time?
Okay, sir, we will keep the time.
Thank you. So yeah, and I think it would be helpful if parties get sort of 1 minute notice heads up before their time expires. And we want to make sure that we complete this within the prescribed time. At any point during the proceedings, I can ask you questions, I can seek clarifications. At any point in the proceedings, the opposing counsel can also, I would request them to raise their hand and then ask a question. But since time is limited, please only ask the important questions. We don't want unnecessary disruption. I'd like to invite the claimants to submit their oral arguments. Sorry, did you hear me? Yeah, I'd like to invite the claimants to submit the oral arguments and start their session. Thank you.
Honorable Tribunal, good morning. Would the 10 minutes be counted with the introductory part as well?
Which introductory part?
I want to introduce my teammates as a coordinator, and then I'll start with my opening.
That's not included. That is not included. Please go ahead.
Okay. Much obliged. Good morning to the chairman of the tribunal and our respected panel members. My name is Sumaya Binti Yusuf, and I'm the coordinator and representing Team Bhuyan Academy. Today, we will be speaking on behalf of our claimant, Hydropump PLC. Before proceeding with the submission, the claimant humbly represents the members of the team. The team consists of 6 members. Sumaya Binti Yusuf will be doing the opening statement and will be doing the cross-examination of the witness, Mizanur Rahman. Khondokar Sadiq Naib will be doing the chief of Maisha Farade. Maisha Famida Sharkar will be doing the chief of Gulian Lawson. Tamjid Tashfi will chief Rohit Sharma Zaruddin. Aryan Fardin will be doing the cross-examination of Binod Kumar and closing statement. Lastly, Tamjid Tashfi will be doing the rebuttal after the closing statement. Now, may I have your permission to proceed with my opening statement, Honorable Tribunal? Much obliged. With this, the claimant respectfully contends that the Honorable Arbitration Panel has jurisdiction to hear this issue. It is clearly stated in Article 21 of the CELS Agreement that the Court of Bangladesh have exclusive jurisdiction over any dispute arising out of or in connection with the contract, including any contract, any question concerning its existence, validity, or termination subject to the buyer's right to go to the arbitration under paragraph 2. And also the buyer has the right to bring any dispute regarding this to the BIAC Arbitration Rules 2019, which are assumed to be incorporated by reference into this article. Moreover, the Arbitration Tribunal is also empowered under Rule 21 of the BIAC Arbitration Rules 2019 to rule on its own jurisdiction, including any challenges to the existence or legality of the arbitration agreement. As a result, this panel has absolute authority to hear the dispute between today's claimant and respondent. 3 arbitrators shall be appointed. Dhaka, Bangladesh shall be the seat or legal location of the arbitration. The language of the arbitration proceeding will be English. The contract's controlling law shall be Bangladesh substantive law. The claimant respectfully provides the factual background of the case. Claimant was granted the tender contract on July 15, 2014. Claimant's pump hydro power plant design incorporated respondents' freshly built, innovative, and powerful R27V Francis turbine, which was one of the reasons for its winning offer. Because just 2 turbines were required to provide the required output of 600 megawatt, the adoption of the turbines allowed for a more ecologically friendly design of the plant. The claimant paid the amount of 20 crore per turbines, totaling 40 crores. 5 crores advance for each turbine and 7.5 crore for each after 6 months, and the rest 7.5 crores each after paid after the installation. On 29th September 2022, The leading daily news feed of renewable energy, the Renewable Daily News, published a report where it was stated that the good quality steel has delivered untested steel of lower quality was also the most likely reason for a disconcerting finding at a turbine produced by the respondent and used in the Riverdale tidal power plant. The turbine had to be replaced after 2 years of operation due to excessive corrosion and cavitation damage. And when it was informed to Mr. Emre, the chief negotiator and the CEO of Turbo Limited, as he suggested to wait until September 2023 for the first inspection, and he was not agreeing for replacement as well. The main purpose for the contract, as mentioned in preamble, was to minimize the risk of having to rely on energy produced by non-renewable sources by providing a largely uninterrupted supply of hydro energy. Honorable Tribunal.
If I may, did you just rely on that report to conclude that there was something wrong with the turbines, or did you independently verify through other sources as well?
The turbines that were defected was of Riverdale tidal power plant that has used the steel that was used in our turbines as well, which I will be discussing down below, Honorable Tribunal.
No, my question is, what was the source of your information? Was it just that report?
It was a report. It was a report, Honorable Tribunal, that was published by the Riverdale tidal power plant.
And that's the only piece of information you relied on, or did you cross-check or verify through other sources?
No, Honorable Tribunal. After that, we also did a metal test. And the expert report showed that the amount of chromium that is required in the steel for the turbines is pretty similar to the Riverdale tidal power plant. So on that basis, we are concluding that if the tidal power plant of Riverdale got defected, then our tidal power plant will also get defected.
Thank you.
Thank you. Honorable Tribunal, the claimant humbly highlights that there was a misstatement of fact and tried to fabricate the fact. It was found in the agreed fact in para 3 that on 3rd October, when the article was published, Ms. Maisha Faraday, the claimant CEO, immediately contacted Emre Khan, the respondent's chief negotiator. And after that, on 4th October 2022, Binod Kumar, respondent CEO, replied to that mail. But in the respondent submission, they have mentioned that it was Emre Khan who has sent them the email, but it was not written in the agreed fact. Apart from that, in witness statement of Binod Kumar, nothing was mentioned about the emails that was exchanged with Maisha Faraday regarding the replacement or inspection. It was also mentioned in the agreed fact as well. Honorable Tribunal, the first issue is that the good does not meet the description, and secondly, it does not reasonably fit for the purpose. I would discuss section 15 of Sales of Goods Act 1930. It was said that where there is a contract for sale of goods by description, there is an implied condition that the goods shall correspond with the description. They claim that their turbines are of top-notch quality, and also in the sales agreement, Article 2, subsection E, it was mentioned that they foresee 40 years lifetime of the turbines. Honorable Tribunal, my argument on this basis would be that they have also supplied turbines to Riverdale power plant, and it had to stop after 2 years of operation. And after conducting a metal test, the report provided that the chromium percentage found in the metal present in R27 franchise turbines is 11.5%, and in Riverdale it was 11.2%. Here, the deviation from the international standard criterion is quite significant, which makes the alloy highly susceptible to corrosion from running water. Thus, it does not match with the description, as there is no guarantee whether this plant will survive for the next 4 years or not. Honorable Tribunal, the claimant humbly submits the second issue, that is the turbines are not reasonably fit for the purpose. Section 16 of Sales of Goods Act 1930 states about the implied condition of fitness and quality. As Turbo Energy has specifically mentioned that they would provide premium quality turbines and have assured us that the best quality steel has been used in the turbines. But seeing the report, it can easily be conducted that it does not fulfill the standard and thus has a high possibility to get corroded and cavitation growing, and could be said to have the same consequences as Riverdale tidal power plant, which clearly shows that the good is not reasonably fit for the purpose. Honorable Tribunal, the claimant humbly submits the third issue, and that is the breach of the aforesaid implied terms. In Article 20, Section 2, subsection D, it was mentioned that the breach shall be considered to be fundamental if it deprives the buyers of what it entitles to expect under the contract. As they provided the steel of lower quality, which does not meet the internationally accepted standard, and also they guaranteed a 4 years and 40 years of lifetime, which seems unreasonable after getting the expert report. Arguably, even if they did not take the steel from the good quality as mentioned in the agreed fact, the Turbo Energy has mentioned in their sales record book that was given by the respondent that the Riverdale power plant has purchased the turbines from the Turbo Energy Limited company. Hence, we can easily conclude that if those turbines get defected, then ours will definitely get defected. Honorable Tribunal, the claimant submits that the Green City has stopped its activities since 21st October 2020. As we have mentioned that each day the claimant has to pay 40 lakhs for the non-availability of power plant. It is also mentioned in the agreed fact as well, which is the consequential loss. Since then, till the date of hearing, we have already suffered a loss of 11 crore 60 lakhs. And as Green City has mentioned that they will terminate the contract on 1st December 2022, if not replaced or inspected. So you can imagine the loss that we will suffer further. Honorable Tribunal, it is submitted that Section 73 of the Act, Contract Act 1872, states that when a contract has been broken, the party who suffers such breach is entitled to receive from the party who has broken the contract.
1 minute left.
Okay. Thus, considering the fact the steel was subpar and does not meet the criteria of the international standards set for a premium quality water turbines, as can be seen in the report provided by the claimant, as it's significantly below the international standard level. It is submitted that to this case entitles us to receive damages under Section 73 due to fundamental breach concerning in contrary to the statutory implied terms of the contract, as the primary component, which comprises 95% of the water turbine, is stainless steel, which has been shown to be faulty. Another criterion of this section, which is foreseeability of the possible damage to occur, can be said to have met as per the information given above, which is obviously known to the respondent, as they're the manufacturer of the water turbines themselves. Honorable Tribunal, it is submitted that the Green City is not willing to take any kind of risk. Hence, they stopped all the activities as 1 lakh people stay there and their second line of employment is sustainable farming. If taking a risk of waiting to get defected, then it's going to be a complete destruction of the whole power plant, as Green City is also segregated from the locality as well. And also, if nothing is done, the Green City will terminate the contract, which will cause a greater loss. So the Turbo Energy either replaces or give us the amount for replacement, that is 40 crores with interest. Alternatively, permit rescission of contract and pay 29,000 of consequential damage caused due to hydropower plant shutdown. That is 11 crores 60 lakh with interest. Hence, it becomes terminable. Rest of the points will be discussed briefly in the closing statement by my co-counselor.
Thank you, Counsel. Can we have your first witness now, and you can proceed with the examination, Chief?
May I request Khondokar Sadiq Naib to come and do the chief examination of Ms. Maisa Faraday.
Good morning. With the permission of the Honorable Tribunal, I, Khondokar Sadiq Naib, the counsel from the claimant's side, would like to start the examination in chief of our first witness, Ms. Maisa Faraday. Honorable Tribunal, may I proceed with my examination?
Please proceed.
Much obliged. Ms. Faraday, am I audible to you?
Yes, I can hear you.
Okay. Could you please mention your name and occupation for the tribunal, please?
My name is Maisa Faraday, and I work in Hydropump PLC.
How long have you been serving for the claimant?
I've been CEO of the company for around more than 10 years.
Okay. Could you please elaborate the services that your company offers?
Well, we're a market leader of making power plants around the world. We make power plants around the world. We have thousands of projects around the world. We have an ISO listed publicly traded company. And yeah, we just make hydropower plants.
So coming to the facts.
Sorry to interrupt, Mr. Tamzid, could you please turn on your video? Okay, thank you.
Okay, can we proceed?
Okay. So can you please tell us what actually happened in January 2014?
Well, in January 2014, the Green City councillors invited tenders for the construction of a hydropower plant in their city, Green City.
Okay. So did you get the tender?
Yeah, we got the tender.
What did you do after hearing about the confirmation of the tender?
Well, we did not actually wait for the confirmation of tender before they even like confirmed the tender. We started looking for turbine manufacturers, and we had communication between Councillor Lawson about his preferences and requirements. So one of the reasons he has mentioned that he would really like in his power plant would be the R27V Francis turbines, which are like state of the art. So this turbine itself, according to the councillor, was very environmentally friendly and was of an environmentally friendly design. And we only need just two turbines to guarantee the power of 600 megawatts. So we made sure we communicated with Turbo Energy Limited for those two turbines before we even got confirmation.
Okay, so what happened after that? When did you come into a contract with Turbo Limited?
We contacted Turbo Energy and they accepted. They accept that if the underlying contract is given to us, we will make a sales agreement of two turbines that will be given to us after the completion of the said hydropower plant in Green City.
Okay, and what is the price of the said turbines?
The price of the said turbines was 20 crores plus we agreed to pay 10% more in terms of the purchase price.
So you agreed to pay 10% more in terms of purchase price. Where's that?
Let me refresh my memory. That would be because they gave us guarantee in their initial pitch that they gave us that it would be corrosion resistant and it would take less maintenance time, which is very important because the Councillor Lawson has indicated that they needed less maintenance time. So they don't have to rely on other sources of energy, bad energy as they like to call it, and that that the technology is state of the art. It's of premium quality steel. And yeah, that's it. It costs us 10% more. So it costs us like 4 crores more. Yeah.
All right, then. Moving on to September 2022. When were the turbines installed?
I think it was in late spring of 2022.
So everything went according to the plan. What happened after the installation?
There was inspections and acceptance tests by the relevant authority that was up to Green City. Green City made that.
Okay, so
I think it was the Bangladesh standards and testing institution, the main institution that dictates what standard of steel needed to make power plants. So Green City was the one who had control of those tests. So yeah, those tests
Green
were
City conducted the acceptance test. All right.
Yeah.
So what was the result of the acceptance test?
All of them
in
are
terms of
passed.
quality of the steel.
Well, we made tests on the physical surface properties of the steel, and all of them passed. Positive.
Okay.
The
So
inspection and the acceptance test.
as you mentioned in your statement, why do you think the chemical defect of the steel was not discovered upon the test?
Because we didn't do any tests on the chemical properties. It's not possible to do any chemical properties tests at that point. So we only did the physical surface properties of the steel, not the chemical properties. So no problem, was discovered.
What happened after the installation and passing the acceptance test? Was there any problem?
Well, they transferred us the turbines. After that, I'm sorry, could you repeat that question?
What happened after successful installation and passing of the acceptance test?
What happened was that we got a report on 29 September we got this report about, I think it's from the Daily News.
Yeah, okay.
I think it was from like some Daily News, some report about like some article.
What was the report about? What did you do upon learning about the report?
Basically, the report was about that
Sorry.
there was an investigative report, and basically what they said was that the steel that was used in Riverdale, there was a complete shutdown of the Riverdale power plant, and the reason for that was the steel was untested, so the heating element was not tested at all. So when it came to actual functioning of the turbines, the steel overheated and it didn't work. So and they needed like huge maintenance time. And in just 2 years, it shut down. So there was a report that the steel was actually from good quality and good quality steel. And we knew, and we found reports that good quality steel was their main
Okay,
supplier of
what
steel.
did you
So
do
we were very
after-
concerned.
Yeah, what did you do after hearing about that? Did you
Sorry,
take
could you
any
repeat that?
actions?
Hmm?
What actions did you take after hearing about the report?
Well, we immediately contacted the chief interrogator, sorry, the chief negotiator of Turbo Energy Limited. I think it was Emre Khan. Yeah, we communicated. We told him about the problem, and yeah, that's it. We told him about the problem. We also contacted Gillian Lawson. We let him know what's going on, and yeah, that's it.
Upon your previously mentioned actions, what did you find out?
Well, first of all, Mr. Emre Khan just said that we're going to contact the CEO and get back to you. And I think that was on, let me be precise with the dates. I think that was on 3rd October.
What
Yeah, that was on 3rd October,
What
right?
was
That was
Emre
on-
Khan's reply?
Emre Khan just said, Mr. Khan just said that he's gonna get back. He's gonna forward this message to the CEO. He's gonna get back to us after like consultation of the CEO from his CEO. And after that, we also contacted Gillian Lawson, right, the counselor.
Okay.
And
So
Mr.
you
Lawson was
contacted
furious
Mr.
about it.
Lawson?
Yeah, we contacted Mr. Lawson about it, and
What
he
did
was
he say?
furious about it.
How did he react to that?
He was furious. He was furious about it. He
And why is that?
immediately threatened to terminate the contract, and he gave us a notice that we have to replace those set turbines, or there is a notice for termination. And that
So after Mr. Lawson's mail, being a CEO, what did you do?
So
Did
we had a back and forth with the CEO of Turbo Energy Limited. I think the CEO's name is Binod Kumar. We had a conversation with him.
Okay, and
told
what
him
was the
about the issue.
consequences of the communication with Mr. Binod?
We had conversations about, we had 4 emails, I think, back and forth, 4 emails. We told him about the underlying problems, and they weren't cooperative at all. They didn't say much. They weren't cooperative at all. We immediately told them that if those set turbines were not replaced, replaced, the contract will be terminated. Plus, the power plant is already no activity was allowed in the power plant as dictated by Mr. Gillian Lawson, because like the turbines were not replaced yet.
Thank you, Ms. Farde. Honorable Tribunal, I think that will be all. Thank you.
Thank you. I'd like to invite the counsel for the respondent to conduct the cross-examination.
Thank you, Honorable Arbitrator. Am I audible?
Yes, you are. Can you please turn on your video?
May I proceed with the cross-examination?
Yes.
Well, thank you. Ms. Maisha Faraday, are you the CEO of Hydropump PLC?
Yes, I am.
For how long you have been as CEO of Hydropump PLC?
I'm not sure. Let me check. Long time. I really can't remember. I don't know. 10 years, more than 10 years. I don't know. I've been working here for a long time. It has been, I think I don't know. It has been almost over 10 years. I don't even remember. It's yeah, a lot of years.
So you are well known in this company. So why did you choose Turbo Energy Limited?
Why did I start? I'm sorry, I didn't hear your question.
Why did you choose Turbo Energy Limited?
Oh, I chose it because basically I had certification from MIT that I was on rocket science basically, but I didn't really like it. So I was like job hopping, different companies, and I was job hopping different companies until I think I got this offer from this other power company, and I really liked the job. So, and then Hydropump PLC actually gave me an offer which I liked. It's good salary, so yeah, I accepted that. Yeah.
Mr. Tamzid, may I request you just keep your answers short and just answer the question that's being asked? Thank you.
Sir, he asked me why did I join. I thought it was supposed to be a broad answer. He asked me why I joined.
Yeah, I think the council should inform you to keep your answer short and just be very precise. Thank you.
My apologies.
My question to you was, why did you choose Turbo Energy Limited to do business? Not why did you choose your own company?
Oh, I'm sorry. I didn't hear you. I didn't hear your question. Why did I choose Turbo Energy Limited to be for the? Could you repeat that again? Sorry.
Why did you choose Turbo Energy Limited to do business with you?
Oh, why did I choose? Okay, so before, so in our line of work, before we even make a bid, we make a market analysis on what exactly the bidder is actually asking for. So what my report showed that Mr. Julian Lawson actually wanted R27V Francis turbines, which according to him was the state of the art and the most best turbines you can find in the market, right? So as soon as we got that information, we started scouting. Sorry,
Miss Maisha Farada, I would like to request you to keep your answer short because we are running out of time.
Oh,
So
I'm
you are assuring that you are aware of the reputation of Turbo Energy Limited, that they are well reputed in the market, right?
Yes, they're very much well reported in the market. We actually got the report, and that's one of the reasons. Like they have the R27V Francis turbines. That was the main reason.
And your specific reason.
My specific
reason
was that,
to choose let me finish my question first. My specific reason to choose turbine was for the R27V turbine.
I'm sorry, sir. Your audio didn't go. I didn't hear, sir. I'm sorry. I think there's something wrong with the internet connection. It just.
Reason choosing Turbo Energy Limited was R27V, right? Turbine R27.
Yes, that's the reason. Like we found that the U-cell Francis are R27V turbines. So yeah, that was one of the main reasons we actually. That was one of the reasons we actually picked you. I'm sorry, arbitrator. My apologies, but the audio is not coming. The internet connection is kind of shady. I think it's okay from my side, but I can actually hear the counselor.
Is he still in the meeting? I think he might have lost him. Hang on. Yeah. I'm not sure if he's still in the meeting.
He is facing some internet issues. He'll be right back.
So should we wait for him to join, or can the other council proceed?
Am I audible right now?
Yes.
Okay, sorry for the
If it's easy for you, you can keep your video off. Yeah.
Well, as I was saying,
My apologies, sir. The audio is not coming at all.
Your voice keeps breaking up.
It keeps breaking. I can't actually understand the full sentence.
Yeah, Mr. Tasin, do you have another connection that you can use? Or can the co-counsel proceed on your behalf?
Hello, am I audible right now?
Yes.
I think it's okay now.
Yeah, thank you.
Please go ahead.
So, Ms. Maisha Farada, did you face the problem with turbine?
Did I face any problems with the turbine?
Are you facing? Are you facing any problem with the turbine right now?
Yes, we are.
What problem?
The turbines are closed because the quality of steel was not maintained.
Well, why do you think that the quality of steel was not maintained?
Because the chromium content is not in level with the international standard.
Or is it for the Riverdale news?
No, the chromium content. The chromium content from the expert report, it says it's not an international standard.
Well, the respondent have their own report or regarding the steel quality. Are you aware
Sure.
of that? Are
Yes,
you
I'm
aware
aware
of
of
the
that.
report?
Yes, I'm aware of that. I'm aware of that report.
Well, and as you say that the relevant authority is Green City, whereas in sales agreement article 18, it is clearly stated that the buyer is supposed to be the do the acceptance test, right?
The acceptance is for the physical surface,
Yes,
physical
the
surface property,
acceptance
not the
test
chemical
must be done
property.
by the buyer, not the Green City
No, no,
Council.
no, no. The buyer has to do the physical surface property test, not the chemical property test. It's two different things, sir. It's two different scientific terms.
Where is the specific test you are claiming for?
We did tests that is on the sales agreement that says physical, not we, the relevant authority. That was the authority that was subcontracted, whatever. The authority is under.
But the authority should be the buyer, not the Green City Council.
Whoever is a third party, but whatever it is, like they did a physical surface test, but nowhere does it say in the sales argument.
But you are breaching the sales agreement by allowing the Green City Council to examine the test. You are breaching the sales agreement according to Article 18. Are you aware of that?
No, we're not.
Yes,
because no, you can't just accuse me like that. No, you're not, sir. If
you can check Article 18 of the sales agreement. There is
the buyer is not obligated to do any acceptance test, sir. That's not what it says.
And you communicate with the CEO of Turbo Energy Limited, right?
Sorry?
You have communicate about the issue with Turbo Energy Limited, right?
Yes, of course.
Mr.
We
Binod
have
Kumar.
we sent 4 emails from 3rd October to
and you mentioned that there was a negligence from our from the communication, but don't you think that Binod Kumar have always replied to your mail and assured you that he is going to fix the problem?
Okay, so sure, he didn't give us a report.
So how do you say that Binod Kumar showed negligence on not responding you accordingly?
Sir, if you allow me to answer, it's just like too many questions. If you could just allow me to answer one question, then you can go to another question, then I'll answer that question. Okay, so what was your last question?
You have claimed that Binod Kumar have problem regarding the communication, like Binod Kumar have showed negligence on communication regarding the problem you're claiming, right? Yeah. But I can clearly see the mails that Binod Kumar have responded every mail, particularly answering all the questions. Not only that, we have also ensured you that the problem will be solved.
May I answer?
Yes, you may.
Have you seen the contents in the email?
Yes, I have.
Well, what does the contents in the email say?
Like, didn't you read the content? You're asking.
No, I'm asking you. You said he gave assurances, so I'm asking you, what was
in the
content
but I can see in the email that Binod Kumar have stated everything, whatever you have asked.
Well, no, he didn't. Then you have not seen the contents of the email, sir. He has not. That's the issue here.
What was his response? According to you, what was Binod Kumar response to your email?
Let me be precise. Let me just open the evidence, and that'd be better, I guess.
Yes.
Okay, where's the email? Let me see. Let me ask one. Hold on. Let me see the email.
Well, in all the you are accepting that you have communicated with the 4 emails, and this shows that we have replied to all the emails, which means that there were no negligence from our side, right?
No, that's not what I'm agreeing to. I said that, okay, let's open the emails and see the contents for itself. I said that I have a problem with the contents with the emails. I never said he didn't reply to any of the emails. I said there was negligence on his reply, on his response, because the contents of the email suggest so.
Well, and if you connect with the case in regarding the Riverdale issue, You know that that was a problem in terms of good quality steel limited, and they are not only the supplier of our company. We have more other suppliers. Are you aware of that?
Sorry, I didn't get it, sir.
Are you aware of that? That Turbo Energy Limited is not only bound to take steel from good quality steels, but they have also alternative suppliers regarding supplying steel.
Sir, I don't know your ins and outs of where you get your steel manufacturers, sir. Like, how would I get that information? I don't know. And yeah,
Then
the
why are you
obviously, like,
assuming that we have taken the steel from good quality steel?
yeah, sure. We because there is no like finite evidence. We are assuming it because it's just a report.
Honorable
Assuming on the fact.
Tribunal, we are done with the cross-examination. Thank you.
Thank you, counsel. Can we have your second witness now? Claimant, counsel for the claimants, can we have the
May I
second
request Maisha Famida Sarkar to come and do the chief examination of the second witness, Lawson.
Honorable Tribunal, may I proceed in chiefing Mr. Lawson?
Yes, please.
So, could you please mention your name and occupation to the court?
My name is Gillian Lawson, and I'm the city councillor for the Green City Council.
What was the aim of your city council?
The aim of our city council was to make Green City a totally renewable energy dependent city, and by having to rely as less as possible or totally avoid the reliance on carbon-based energy.
What did you do, especially in 2014, in terms of the energy supply of your city?
In 2014, we decided to make this aim of ours reality, decided to make it reality and go forward by releasing a tender for companies to bid for the construction of a hydroelectric power plant.
Whose tender bid did you accept?
We accepted the tender bid from Hydro Pump PLC.
Why?
Because one of the criteria for our power plant, which we outlined, was that we wanted for the maintenance of the power plant, we wanted long intervals between maintenance and short maintenance periods. And upon the presentation from Hydro Pump PLC, we got to know that the turbines they were offering, water turbines they were offering, which were the R2070 Francis turbines, were compliant with those criteria, which is one of the major reasons we gave them the tender.
Recently, the turbines were successfully installed in your city, weren't they?
Yes, I believe it was on the 19th of September 2022 that the power plant has started operating after the installation.
What happened after that?
After that, on the 4th of October, Ms. Maisha Faraday contacted me about a particular report and article which she got to find out where good quality steel was allegedly defrauding their customers by making false steel quality certificates. And Turbo Energy was a part of it, and also Turbo Energy was the ones who supply the water turbines in our power plant.
Okay, so what did you do upon your communication with Ms. Maisha Faraday?
Upon getting this email from Ms. Maisha Faraday, immediately contacted her back, stating the fact that I was obviously outraged about this, and told her that you contact Turbo Energy immediately and get them to replace our turbines. Otherwise, I will terminate our contract with them within the 1st of December. And also, as the reason for the Riverdale power plant to shut down was excessive corrosion and cavitation damages, the corrosion leads to our water stream being poisoned. So we would not risk it at all, which is why we decided to shut down all operations of the power plant since 21st November to avoid the further risk to our people and our sustainable livelihood.
Honorable Tribunal, that was all.
Thank you. May I ask Counsel for the respondent to conduct a cross-examination?
Thank you so much, Honorable Arbitrator, for giving me the opportunity. So,
Honorable Arbitrator, if I may, could the council speak a bit louder? The voice is audible.
am I audible now?
Yes.
So, Mr. Gillian Lawson, is it true that you're the councillor of Green City?
Yes, it is.
Okay. How long have you been working with Green City?
I've been working with Green City for more than past 8 years.
Okay. Are you aware of the fact that hydropower would take supplies from a third-party company before you gave them the tender
Yes,
contract?
they notified us of the fact that they were in talks with Turbo Energy for the turbines in case they got the tender from us.
Okay, before hearing from the hydropower about the Turbo Energy Limited, did you ever heard about the company before the contract?
Before the contract, I mean, obviously I've heard about it here and there. I was thinking of making a hydroelectric power plant. Obviously, I will do my own market research as well and get to know the companies that are available and also what the companies they are relating to.
Okay, since you you signed the contract with hydropower company, knowing the fact that Turbo Energy was the third-party company, so I will assume that you think Turbo Energy is a good and reliable company. Am I right?
I would not think so, but just because one of the product is said to be claimed to be very good, I wouldn't not exactly make that claim myself that they're a very good company. That is not for me to make a claim. I'm not the authority here.
So you want to say that you were not sure about the good reputation or goodwill of the Turbo Energy Limited.
I was not getting into a contract with Turbo Energy. I was getting a contract with Hydro Pump PLC. The product that they featured was from our Turbo Energy. So what I only looked at was the product and the way it was featured. So now, obviously, as any self-respecting man, I would think that Turbo Energy would do business in good faith and give the proper description of the turbine, which is why we accepted it in the first place.
Okay. Okay. Before signing the contract, did you verify the source from where hydropower would take the supplies?
Yes, from Turbo Energy, it was from the very beginning. That is why we gave them the tender from Turbo Energy, and they showed us a PowerPoint presentation, which apparently Turbo Energy showed them regarding the description of the product.
Okay, so you were pretty much convinced that they have the right quality products, the Turbo Energy.
Yes, upon the presentation shown to me by Turbo, which was made by Turbo Energy, yes, after that, I got confirmed that this was good.
Okay, didn't you double check? Was the presentation all?
The presentation and the company pledging, yes, and with the company knowing what our criteria are and still saying that, yes, they will meet those criteria. Further testing of what exactly what kind of a test are you talking about? Asking me here.
I'm asking about that, how authentic your source was and how good the products were. Did you double check or did you do any background checking?
Our product is the power plant. We cannot keep on checking every third party, every company we relate to, and check their historical background and everything. We expect companies to work in proper good faith and act in good faith with us, as we ourselves would always do. We do not assume that someone would be acting in malafide.
Okay. You were very much aware that there was not any clause accounting the third party in your tender agreement. Am I right?
Yes.
There was
that is true.
so okay.
Because the third party is not my concern.
Okay. So is it true that when you heard about the inferior steel, you threatened them to cancel the contract?
Yes, it is true.
Okay. How was their reply after you threatened them to cancel the contract? How did Ms. Maisha
a bit correction here. We did not only threaten to terminate the contract. We told them that get the turbines replaced with whoever you dealt with, and if you are unable to do that, that is when we will terminate the contract. We gave them an out first, not exactly said that we will terminate the contract no matter what.
Okay. So that's all from my side. No more questions. Thank you so much.
Thank you.
Thank you, Council. May I now invite the respondents, Council, to proceed with their oral arguments. And so we're done with the first session. that primarily involved the claimants submitting their arguments and presenting their witnesses. And now we proceed to the next phase of the hearing, in which the respondents will be submitting their oral arguments, opening statement, followed by
Honorable
a
Tribunal,
presentation
we
of their
have two
witnesses.
more witnesses.
Two more witnesses?
Yes.
I thought you just had two witnesses. I don't see that in the program either.
No, we gave the list. When we gave the list, it was mentioned that we had 4 witnesses in the exhibits as well.
But how will you complete that within the allotted time? Don't you have another 10 minutes left?
Yes,
Or
we have 12 minutes left.
So we're gonna, Honorable Tribunal, we're gonna take 5 minutes each for the chief and the cross as well.
Yes, like as they have 12 minutes left, so I think they can.
that's fine. Yeah, please go ahead.
Morning, sir. This is the counselor from the claimant side. And will be. Can you hear me, sir? This is
Yes.
the counsel from the claimant side, and we'll be doing chief examination on Rohit Sharma, the CEO of Good Quality Steel.
Please proceed.
I think he's ready. May I
understand this correctly? There are 3 counsels for the claimant?
Yes.
So there's 3 counsels. I thought there were 2 counsels for the
No,
claimant.
there's sir, there's
3,
3.
the third one. Okay.
May I continue, sir?
You're wearing a different hat now. You're not a witness anymore.
Sir, could
Okay,
you
please
please
proceed.
tell the court? Sorry, my apologies, sir. Your voice broke. If I may continue, could you please tell the court your name
Yes,
and your
please.
occupation?
I'm Rohit Sharma, the CEO of Good Quality Steel.
Okay, Mr. Rohit Sharma, what are the products that you sell in your in your company?
We sell different grades of steel all over the world.
So who are your main
Sir.
customers for this steel, sir?
Worldwide, we supply steel to many different companies, but our main customers are Ranks Development, Turbo Energy Limited, and Aliza Glass Factory.
That's enough, sir.
Like
So how long have you been in business with Turbo Energy Limited?
Almost 20 years now.
Okay. So as you had mentioned, Turbo Energy is one of your main buyers. How much steel do you contribute to their ultimate manufacturing purpose?
Well, I believe approximately 60% of the steel that they use are supplied by us. Yeah, I believe.
Okay. So were you requested to supply steel to Turbo Energy Limited in the second half of 2014?
Yes. Yes, I clearly remember, and we did it successfully.
That would be all, sir.
Thank you.
May I call the next witness? That
Thank
would be
you. May I invite the respondent's counsel to conduct cross-examination? So no cross-examination? You want to
Thank you,
do the
arbitrator.
examination chief first and then?
Thank you, arbitrator. I would like to cross-examine Rohit Sharma.
Please proceed.
Mr. Rohit Sharma, are you the CEO of the Good Quality Steel?
Yes.
And how long you are doing this business?
Around 20 years.
20 years. And how long you know Turbo Energy Limited?
Yeah, almost it's the same, almost like 20 years now.
So you know Turbo Energy Limited for 20 years.
Approximately.
And how was your business relationship between you and Turbo Energy Limited?
It was good. It was quite good. They are our main customers. We are supplying them for 20 years now. And yeah, that's pretty much.
Well, before I proceed to next question, I would like to know that why do you think as witness you are important for claimant's party?
I don't know. You bring me here. You tell me.
Well, I'm not the one who brought you here. I say that why do you think as witness
I'm just a
you are
witness. I'm
important
just a witness.
for
Ask
claimant?
my claimant. I don't know. You called me. I'm here.
That
me,
is
what
my
can I do?
question. That why do you think in this case, when the case is with
Well,
Turbo Energy Limited,
it's not my job.
and you
It's not my job. I was being
Okay.
called, so I'm here. I'm giving my time.
and do you
Do
think
you have any
that
problem
do
with
you
that?
think that do you think that Turbo Energy Limited take all the steel only from you?
I won't say that. Not all the steels, but Yeah, we are the main suppliers, approximately 60 or maybe 70, I don't know, but yeah,
Well,
we are the main
what do you
suppliers.
want to what do you want to state regarding the Riverdale case?
Not that much.
I mean, your statement, I just want to
Huh.
know your statement regarding the Riverdale case.
Okay. Is Riverdale the respondent?
No, Riverdale is not the respondent. I
How come it's
hope
11?
that you're aware of the fact of Riverdale, right? So I want to know your statement
What
regarding
fact?
the
What
Riverdale
fact?
case.
Sorry.
The problem that the Riverdale claim.
Well, that's a different case. We are not here for.
Yeah, that's a different
solving
case,
that
but
today.
it is
Yeah.
related, very much related with this case. So how do you state about the problem that
Yeah, I
Riverdale
had the
faced?
reports. I had the reports. I saw them. We are alleged, but it's not proven yet.
Well, and don't you think that the problem that arise today's arbitration, don't you think that you are one of the person behind this problem?
I don't think so. The litigation is ongoing, and we can solve that somewhere else. But not
And
today, I
how do you
think.
justify your quality steel, like your quality of steel, like justify your quality of steel?
Sorry.
Your quality of steel. Can you justify your quality of steel that you are supplying in the market is fair enough to do business?
Obviously, otherwise, how are you running our business? What do you think?
Well, then how did the claim came against Riverdale and now with
Well,
this
it's not proven yet.
hydropump company?
Sorry, I don't know your name. It's not proven yet. You can't tell me that we have any problem with the steel.
Then why
Allegations keep coming,
if the
but it's
problem
not
is not
proven
proven
yet.
yet, but
Yeah.
you are as a witness of the claimant party who himself is facing the problem? But how can you say that the
Sorry, I
problem is
didn't
not
get your
proven?
question. Sorry.
You are being the witness of claimant party and you are
Yes, I
saying
am.
that the problem is not proven yet. However, the claimant party is right now today in this arbitration for the problem, and you are one of the supplier of Turbo Energy Limited. So don't you think that you have a role, or you are the reason behind this problem?
Well, I would say so, but the respondent said that they didn't use our steel. So how can I say something about that?
Are you sure about that? The respondent didn't use your steel?
Please check, mister. I'm sure.
Okay. Thank you.
Welcome.
Counsel for the claimants, do you have another witness? We have about 3 minutes left.
Yes, sir. We have another witness.
Okay.
The next witness, please turn on your video, please. Sir, may I proceed?
Please, and you have 3 minutes, so please try to
Okay,
adhere to
so
the timelines.
my apologies for interrupting you, sir. Could you please state your name and occupation?
I am Azharuddin, CEO of Riverdale Power Plant.
Okay, so let me get to brass tacks. So was there any acceptance test for the R27V Francis turbines in Riverdale Tidal Power Plant? Were there any acceptance tests, inspection tests? Were there?
There was acceptance tests.
Okay, so what were the results of those?
Like upon the inspection, we got to know that the corrosion and cavitation damage was to such an extent that we immediately had to shut down our power plant to protect any further damages in our generator and the power and the plant itself.
Oh, so how long was it closed for? During maintenance? How long was it closed for? Was it 6 months? 2 years? I can't hear you. Sir, I can't hear you. Okay, moving on, no problem. So was there any underlying insurance contract? Should the underlying turbines fail, was there any insurance contract between you and Turbo Energy PLC?
There are some technical issues.
So there are some technical issues. Can we give a pause?
Yeah, I must remind you though that if the cross-examination of this witness is not completed, I will not take the testimony of this witness into account. You just have 1 minute left. So you have to give some time for cross-examination. If the examination, I will not take the witness testimony into account.
It's okay, sir. It's the witness is excused.
So you don't want me to consider the testimony of this witness?
Yes, no need.
Okay, thank you. I think we're now ready to move to the second phase. So may I now invite the respondents, counsel to submit their oral arguments and present their witnesses.
Am I audible?
Yes.
Thank you, Honorable Arbitrator. Very good evening, very good morning. Myself, Farzana Zarinira, Coordinator and the First Counsel on behalf of the respondents. I, along with my teammates, shall represent the respondents Tarbon Energy Limited in this arbitration proceeding between the Hydropump PLC as claimants and Tarbon Energy Limited as the respondents. We have total 6 members. I shall be the first counsel and submit the opening statement. Ms. Sumayya Tabassum and Mr. Wasi Parvez Tassin are the counsels for the cross-examination. Ms. Imtrita Hussain shall conduct the examination in chief of Mr. Binod Kumar and Mr. Mizanur Rahman Khan, and Mr. Abdullah shall submit the closing statement. Honorable Arbitrator, may I have your permission to submit the opening statement on behalf of the respondents? Honorable Arbitrator, may I have your permission to submit the opening statement?
Yes, please proceed.
Much obliged. I briefly present the summary of the case. In January 2014, the Council of Green City invited tenders. Claimant submitted a bid, and on 15 July 2014, claimant was awarded the contract because claimant's pump hydro power plant's design used respondents' newly developed and powerful R27V Francis turbine. On 2nd May 2014, both parties signed a sales agreement according to which respondent was to deliver and install 2 R27V Francis turbines after the claimant was to be awarded the tendered contract. After winning the contract on 15 July 2016, the claimant immediately started the construction of the pump hydro power plant and managed to finalize it in less than 4 years. In late spring 2022, the respondent delivered and installed the 2 R27V Francis turbines. The claimant started operating the plan on 19 September 2022 after the inspection and completion of the acceptance tests, which the claimant was responsible solely according to the sales agreement Article 18. On 29 September 2022, the daily news feed on renewable energy. The Renewable Daily News published a report about the start of a major fraud case against the CEO of Good Quality Steel, one of the respondents' suppliers from among many suppliers of Tarbon Energy Limited. After having been informed about this, Ms. Maisha Faraday, claimant CEO, immediately contacted Tarbon Energy Limited, and Mr. Binod Kumar, respondent CEO, replied regarding all the concerns and suggested waiting until the first inspection. Unfortunately, no viable solution or agreement to come to a solution took place. Honorable Arbitrator, I, on behalf of the respondents, want to submit 4 key arguments. Firstly, there is no breach of contract that took place. Secondly, there is no rationale to believe the anticipation. And thirdly, the claimant party is the one to be accountable. Lastly, the respondent is not negligent and didn't perform unfair activities. Honorable Arbitrator, there is no objective evidence for the breach of the agreement and no occurring reasons of facts. By occurring reason and fact, we mean the failure of the turbine to support the power plant in its course of action. Nowhere did the claimant party prove that the turbines are currently failing to comply with its process. There is still no piece of evidence to be found about the corrosion and cavitation damage in the turbines in the current situation. And all these reasons are objective proof for the respondent to believe that there is no breach of the agreement taking place. And so there should be no immediate question about the respondent's liabilities.
Counsel, I have a question.
Yes.
Counsel, if I may quickly ask a question. So in your industry, in your particular business, speaking about the anticipatory breach issue, you said that currently there is no definitive proof regarding the bad functionality of the engine. But I'm just wondering, how does it usually work in industry? What kind of evidence is sufficient to give your customers valid concern regarding the operation, the functionality of your engines? When can they actually file a claim based on anticipated breach? Because the last thing you want is everything just shuts down. So right, you have to anticipate such a disaster. So what kind of proof would be considered a concrete and valid proof for you to actually consider it to be anticipated breach?
Honorable arbitrator, the steels we used for the pump, the turbines, that was not from the good steel, and we tested from the IIT Madras about the steel we used for the turbines, and that said the steels we used was not defected. Honorable arbitrator, may I proceed?
So this is completely established. You're absolutely sure that the steel wasn't sourced from that company?
Yes, honorable arbitrator. We have evidences.
Okay, thank you.
Much obliged. Secondly, with respect to the theory of anticipatory breach of an agreement, it is understood that any party must exhibit some situation where the other party has reasonable issue to believe that the other party will breach the contract eventually. The assertion of this anticipation is not acceptable, as the claimant has no objective question on the current conduction of the turbines, rather than the whole anticipation is based on a news report of a different incidents taking place at a different power plant. Moreover, an important thing to consider regarding this issue is that the materials used for forming the turbines of the Riverdale plant were taken from the good quality steel, but the materials used for producing the turbines for the hydropump PLC were taken from another supplier named Salsable Enterprise of Turbo Energy Limited, as it has many suppliers other than good quality steel. The emails between the CEO of Turbo Energy Limited and the CEO of Salsable Enterprises regarding the supply of metals and invoice paper of the purchase are clearly presented in the exhibits 2 and 6. Salsable Enterprise are known for their regular practice of metallurgy testing from the Indian Institute of Technology, Madras, one of the most reliable places for metallurgy checkups. There are some doubts about the reliability of and questions regarding the metallurgy test report submitted by the claimant regarding the metal of the turbines, as the reports lack proper etiquette of documentation. For example, the report has no dates which would suggest when exactly the tests were conducted. Moreover, the company Salsable Enterprise presented an authorized and verified document from the IIT on the metallurgy test of the materials used in the turbines for hydropump PLC, and the document has the exact date on which day the tests were conducted, which was during the purchase of the metals by Turbo Energy Limited. From the report of IIT suggests that the materials used for creating the turbo are very much up to the standard, as the level of the chemical are adequate, and especially the level of chromium present in the metals is above 12%. The report mentions that the chromium levels are 13.8%, and the chemical levels present in the metals are adequate for them to be deemed corrosion and cavitation resistant. Coming to my third point, one of the obligations of the buyer, Hydropump PLC, as mentioned in the sales agreement, Article 4, Clause 4, and also in the Article 18, is about the acceptance test, which was the sole responsibility of the buyer to conduct and test whether the delivered turbines was up to the standards and conforms with the tender agreement between the buyer and the Green City criteria. What we know is that the test was passed and everything went smoothly, and the turbine completely met the standard of the tender agreement criteria. That is why the Hydropump PLC boldly decided to start the operation of the turbines in the power plant.
1 minute left.
Thank you. The second confirms that the respondent party is not liable and should not be accounted for this ground. Honorable arbitrator, punitive damages are given for negligence and malicious intentions. Respondents were not negligent, and neither was it intentional or malicious. On 3rd October 2022, after having been informed about this, Ms. Maisha Farade, claimant CEO, immediately contacted Mr. Amar Khan, respondent's chief negotiator, to inquire to what extent the two R27B Francis turbines in the Green City plant could be affected. Binod Kumar, respondent's CEO, replied regarding all the concern and suggested waiting until the first inspection to be pulled forward from September 2023 to September 2024. In accordance with these grounds, it can be clearly understood that continuous availability of respondents was present, replying the claimant's emails within time, answering queries, and also sending our chief negotiator for inspection. This clearly proves that in no justifiable ground, the respondent can be deemed as negligent and unfair.
Objection, Your Honor.
Objection, sir, objection.
Honorable Tribunal.
Who is this?
Sir, apologies, Councillor, forgot to.
Are you the counsel for the claimants?
Counsel for claimant, yes, yes, sir. Sir,
You
objection on the
cannot
grounds of
interrupt her.
mistake.
You cannot interrupt her. Let her finish her arguments, and then you can raise any queries or questions you have later.
Thank you.
Honorable arbitrator, this is all about the arguments that the respondents are going to submit.
Okay. Yeah, then I can ask the counsel of the claimants to please go ahead and raise the objection you have.
Your Honorable Arbiter, the objection is based on the misstatement of fact where the respondent has clearly stated that Emre Khan, the chief negotiator, was sent to our power plant for inspection, where even in the agreed upon facts and in anywhere, no such thing ever happened. We never permitted them to enter our power plant.
Counsel for the respondent, would you like to respond to that objection? Counsel?
Honorable,
Is she still in the meeting?
Honorable arbitrator, we surely sent our chief
All right.
negotiator
Would
for
like
inspection.
Yeah, go ahead. Would you like to respond to that objection?
Yes, Honorable arbitrator, about the question that the counsel for the claimant asked, we surely sent our negotiator for inspection.
Honorable Arbiter, may I make a further point?
Yes, please.
Sir, they're saying they have sent us, we have received no such communication, or we have never given them the allowance to enter our power plant. Only the turbines are there, but the power plant is ours. So how did they make an inspection without us allowing the chief negotiator to enter in the first place?
Okay, I will let the counsel for the respondent respond to this, and then we'll leave it at that. Counsel for the respondent.
Honorable arbitrator, my apologies. We didn't send, but our chief negotiator responded to their queries.
Okay, I will let the record reflect the objection and your responses. And we can now proceed to examination of the witnesses. Counsel for the respondent, could you please present your first witness?
Honorable arbitrator, I'm the counsel from claimant side. May I proceed with the chief examination of Mr. Binod Kumar?
Are you the counsel for the claimants or respondents?
Sorry, sir. Respondent side.
Yeah,
Yes,
please go ahead.
Much obliged. Hello, Mr. Binod Kumar. A very good morning to you. Please introduce yourself to the tribunal.
Thank you, Council. Good morning, honorable arbitrators, and also good morning for everyone. I am Binod Kumar, the CEO of the Turbo Energy Limited company.
Mr. Binod Kumar, kindly tell us about your company and the client relationship you have with other companies.
My company, known as a well-reputed company in Bangladesh for a long time, Although our company is very large and we supply various products to different parts of the country almost every month, we always try to ensure that our customers get the best products. I always tried my best not to create any kind of rift in relationship between our company and our clients, because only good customer service and good product can sustain a company in this world.
Thank you, Mr. Binod Kumar. Mr. Binod Kumar, what can you tell us about the sales agreement that was signed between your company, Turbo Energy Limited, and Hydro Pump PLC?
Witness, I think you're on mute. Could you please unmute?
Sorry, arbitrator. Okay, agreement was signed on
You were on
22
mute.
May. Hello. Yes, am I audible now?
Yes, we can hear you.
Agreement was signed on 22 May 2014 between us, the Turbo Energy Limited, and the Hydro Pump Company. The purpose of the agreement was to produce and deliver to the buyer of our newly developed Francis turbine R27B of 300 megawatt power each. They asked us for 2 turbines. And it was also in the agreement that after the installation of turbines in Green City, we will perform our first inspection of the turbines 3 years after the start of operation at a date to be agreed between the parties after the start of the plant, whereby inspection shall take place during the summer vacation period in Green City, where the energy produced by the other form of renewable is normally sufficient to meet the decreased demand. The purchase price for each turbine was 20 crore.
Mr. Binod Kumar, please tell us the tribunal, what were the steps taken with you when Mr. Maisha contacted your company about the situation?
Look, when Miss Maisha Faraday wanted to talk to me about this matter, the first thing I asked her was if there was a problem with their turbine. The answer was negative. And then I suggested her to wait until the first inspection to be pulled forward from September 2023 to September 2024 to ascertain whether the turbine runner or the blades were produced from steel of inferior quality, and then we will take necessary decision about this. And not only that, as their project size was huge, so I personally assured that lady that we will find a solution in a cool head. But here she shows haste. However, I have tried to reply as quickly as I can to each email from Maisha Faraday.
Thank you, Mr. Binod Kumar. Mr. Binod Kumar, please tell us, what did you do after signing the sales agreement?
In August 2016, I emailed Mr. Mizanur Rahman Khan regarding this matter, who is the CEO of Salsabil Enterprise, where it was written that we have a contract with the hydropump company, as hydropump won the tender of Green City Council for the construction and operation of a pump to generate source of renewable energy. And also I said in my email that we want the best quality product from them, as Salsabil is one of our oldest and trustworthy suppliers. We wanted to purchase all the materials for the hydropump company's turbine from their company, and they respond to me very quickly. Within a few days, they delivered their product with a certificate after verifying their product from a well-known Indian company.
Okay, Mr. Binod Kumar. My next question is, Mr. Binod Kumar, why, please tell us, why did you choose the solution? What did you, I mean, when you said the, Ms. Maisha, why did you choose the solution?
Firstly, our company is very well-known and respected company in this market, and our company has been providing our products to many suppliers and various companies since its establishment till this date. Out of them, only one or two gave bad comments against our product. There are two issues here. First of all, we have never knowingly given a bad product to anyone. And secondly, when I told her that we bought a raw materials for their turbines from Salsaville company, she didn't pay any attention to my words. Also, this was the first product purchased.
Objection, sir.
Counsel, you should not interrupt the examination chief. If you have any questions, you can ask those during the cross-examination.
My apologies.
Can I proceed? Also, this was the first product purchased from us by Hydropump company. I didn't want to break our relationship in the beginning. Also, I was a little disappointed when I saw that she didn't believe in me at all. We all know that business runs on trust, and that's why I felt compelled to make such an offer.
Mr. Vinod Kumar, as you have been in the business for many years now, can you please tell us about the materials that were used for the making of turbines for this project?
Okay, we used alloy, angles, and square bars to make their turbines, and which was collected from Salsaville Enterprise. Being an experienced person in this sector, I know how much and what chemicals should be in various types of product. When they tested their product from a reputed university in India and gave me the certificate, I knew it was a top-class product.
Okay, Mr. Vinod Kumar. After the discussion with claimant, you clearly heard that they were talking about their tested certificate from BIAC, and you have also tested the steel and had a certificate. Can you please tell us about that?
Yeah, I can see that they have given a certificate that came from Bangladesh University of Engineering and Technology. I agreed that the BIAC is a very reputed institution, but the certificate is not a valid certificate because there is no date or official criteria in that paper. It's just a white paper with some ink. On the other hand, if you look at the Salsaville certificate, which was given by IIT, it was an official certificate which has all the criteria that a valid certificate needs. There is a date and a valid signature, and that's why I can say it was a real certificate given by IIT.
Duly noted, Mr. Vinod Kumar. Now, my last question to you is, how are you getting affected by the claims of Ms. Maisha?
Well, I have been saying from the beginning that our company is a well-known and respected company in this sector. We deliver our product to almost all parts of country, and we maintain good relations with them. But since this accident, our relations with many people have deteriorated. We have also taken a big hit in our company shares, which is not good news for us at all.
Thank you, Mr. Vinod Kumar. We're done with our chief examination of witness number 1, Honorable Tribunal. Thank you.
Thank you, counsel. May I now invite the counsel for the claimant to conduct cross-examination.
Thank you, Honorable Arbitrator. Honorable Arbitrator, before I would like to start my questioning, I have two objections regarding the things the witness has stated. Before the two misstatement of facts. One is the Turbo Energy Limited never notifies us of the name of their supplier in any of their communication or any of their conveyances, even when asked about the concerns, and no email was put forward by them either, or we received no such email. Secondly, they stated that our test, this test we made was from BIAC, which is a misstatement, and it has been shown in our exhibits that our report was done by Broker, which is an international metal testing organization, which does metal testing all around the world.
Counsel, do you want these arguments to be part of your written claim, or are you going to frame them as questions as part of your cross-examination? How do you want to address these objections? Would you rather ask these questions of the witness? Because I think that would be more effective. Or do you
Honorable
want these to
arbitrator,
be
this
just
is
a
all of
clarification?
this information was all given in the exhibits.
Okay, so
it was
so
just
your claim is,
misstatement.
yeah. So it's inconsistent with the documentary evidence submitted.
Yes,
Okay,
yes,
noted.
honorable arbitrator.
Please proceed.
May I? Thank you, honorable arbitrator. Before I start asking you questions, Mr. Ben Kumar, I would like to just give you our views that my questions are either 1 or 2 words or mostly yes or no questions. So I would like to request you to give answers accordingly and not waste the honorable arbitrator's time. So my first question to you is, how long have you been the CEO of Turbo Energy Limited?
So maybe it's 14 years or 15 years.
Okay. Do you conduct business internationally?
Sometimes it depends.
Didn't you just say that you conduct business all around the world in your examination in chief? Now you are saying sometimes. What is it exactly?
All of our transactions are international, but some.
Okay. When you do international business, do you comply with all international standards for your products?
Why shouldn't we?
So yes, you do. That is, you are admitting that you do comply with international standards when dealing with your products.
Yes.
When did you receive the certificate or report from Salsabil about the chemical properties of your metal?
During the purchase, when I tell the Salsabil enterprise to give me a certificate with their product, then they give me certificate.
Could you mention the year and an approximate month or date?
2016 date was. Okay.
Okay, no worries. Let's move forward. What is the chromium percentage mentioned in your report?
Around 13.8% or 9%, maybe.
13.8. Okay. And are you 100% sure that that was the steel, particular steel you used to make our clients' turbines?
Yeah, it is our company. We have to know that,
So you are sure that that was the steel used?
Yes.
Yes. Okay. Thank you. So, Mr. Ben Kumar, are you aware of a type of stainless steel named austenitic stainless steel? Should I repeat the question? Are you aware of a type of stainless steel named austenitic stainless steel?
Can you repeat the question?
Are you aware of a type of stainless steel called austenitic stainless steel?
I'm the CEO of the company. I'm not a chemical expert.
Okay, thank you for your. Are you aware that it is the only type of stainless steel internationally accepted for the usage of water turbines, to be used in water turbines?
There are a lot of opinions when it comes into the international standard.
Mr. Ben Kumar, do you know why austenitic stainless steel is the only accepted internationally, for water turbines? Do you know that it is only when there is a chromium percentage of 18 to 25% present in the steel alloy that it can be called austenitic, and austenitic steel is the only steel that can be used to produce water turbines internationally?
Okay, no, the minimum percentage of chromium needs to 12%.
Yes, okay. That is for all sorts of stainless steel. That is the minimum requirement for all stainless steel. Austenitic stainless steel is the only steel accepted worldwide to be used for water turbines. Other sort of stainless steel are used for other stuff, but I'm asking you, do you know that austenitic stainless steel requires 18 to 25% of chromium, and it is the only accepted steel internationally to be used in the manufacturing of water turbines specifically?
your company's transaction with us is a national transaction. It was a national transaction.
So when you said that it is state of the art, world class view, so you were not considering the international standards at all, and now you're saying that it was national. So when you promoted out your turbines to us, you're saying it was of international standards, it was of state of the art quality, best in the world. Now you're saying that it is not national, which is why we should be concerned with that criteria. Okay, thank you, Mrs. So how has your company exactly done international business, as you said, sometimes without knowing this particularly very well-known fact?
Okay, can you repeat the question? I have some internet issue.
Okay, so my question is, you have just said that your company does international business sometimes, right? So be it the national issues, to do business internationally sometimes, you need to know of this particular fact. So how is it that you did international business with those companies you did business with?
Okay, there are a lot of opinions about international standard criteria, but
Mr. Bennett Kumar, it is not an opinion anymore. It is set, the minimum level of chromium set for austenitic stainless steel is 18%, and the the outer side outlier is 25%. So my question is, austenitic steel is the only one accepted internationally for water turbines. You can search up any documentation right now, and you will find it. It is known by every steel manufacturer, every water turbine manufacturer all around the world.
Yeah,
are you saying you did not know that?
I know my job very well. You have some misunderstood, but the criteria minimum 12% and the maximum point is 18%, not other. You should check.
Mr. Bennett Kumar, I have checked and have done my research. That is why I was asking you about this, but it clearly shows that you have inadequate knowledge on your, but thank you for your time.
Okay,
Honorable Arbitrator, I'm done with my questions.
Thank you, Counsel. May I ask Counsel for the respondent to present your second witness?
Now, Honorable Tribunal, I would like to chief examine witness number 2, Mizanur Rahman Khan. May I have your permission, Honorable Arbitrator?
Yes.
Much obliged. Hello, Mr. Mizanur Rahman Khan. Good morning to you. Please kindly introduce yourself to the tribunal.
Good morning, Honorable Tribunal. My name is Mizanur Rahman Khan, and I am the CEO of Salsabil Enterprise, one of the suppliers of Turbo Energy Limited.
Mr. Mizanur Rahman Khan, please tell us, why did you decide to become a witness in this proceeding?
Well, regarding that question, the reason why I chose to come to today's tribunal it's because my company, Salsabil Enterprise and Turbo Energy Limited, have a long business relationship. In the past, we provided a lot of our products and materials to Turbo Energy for their sustainable projects. And so due to this relationship, if I can be of any use, I would like to help the company.
Thank you, Mr. Mizanur Rahman Khan. Can you please tell us about the agreement between you and Turbo Energy Limited?
Well, back in 2016, when Mr. Binod Kumar, the CEO of Turbo Energy Limited company, reached us via an email sharing that Hydro Pump has reached out to them to purchase 2 of their new Francis turbines, and also that they were highly interested to comply with the proposal of Hydro Pump company. And for that, they needed steel materials. So they asked us for it, and we complied and sold the necessary amount and adequate amount of steels needed for the project.
Okay, Mr. Binod Kumar. What are the requirements? Okay, sorry, Mr. Mizanur Rahman Khan. What are the requirements Mr. Binod Kumar always provides for you before purchasing any materials from your company?
So before the supply, one of the main requirements that Turbo Energy requested us was about the testing criteria. The metals should be tested from IIT, the Indian Institute of Technology, Madras, and it should be verified as a good product. Although as a company, we comply with our set standards requirements for checking the steel materials and verifying them before we supply it nationally or internationally, because there are a lot of standards. When it comes to national standards, there are difference of opinions, and when it comes to international standards, there are also difference of opinions. It depends upon companies how they adjust to what kind of standards. There's a lobby between them, and all the businessmen in the international arena are very much aware about it, including us, companies like us. So so due to that reason, when it comes to international transactions, what we try to do it from the Indian Institute of Madras Technology, because they are the most verified and most appropriate for the international clients. And this was very much known to Turbo Energy, but for the better business transaction, the Turbo Energy mentioned it explicitly that we should do it.
Duly noted, Mr. Mizanur Rahman Khan. So my last question to you is, are you going to give Turbo Energy Limited any further material after this incident?
Yes, of course. As I mentioned previously, we have a very strong relationship, a business relationship with Turbo Energy Limited, and we are also involved in many projects with them, and also because we know that this company is a world-renowned one and an expert in its field. That's the whole reason for their sustenance for a long period of time. So we definitely want to continue this relationship.
Thank you, Honorable Tribunal, and thank you, Mr. Mizanur Rahman Khan. I am done, Chief, examining our witness number 2.
Thank you. Counsel for the claimant, please proceed with the cross-examination.
Honorable Tribunal, much obliged. So, Mr. Mizanur Rahman, I have some quick questions for you. You knew that the turbines was used for the water-based power plant, didn't you?
During the purchase of us between, yes.
Okay, so if I say that being a steel supplier, you have adequate knowledge about the steels that your company suppliers use, would I be wrong?
No, you wouldn't be wrong.
And you were aware of the purpose that those steels were being used for, weren't you?
Yes, absolutely, because all of those are documented and I am supposed to be informed. Otherwise, I cannot meet the criteria which our client wants. Because sometimes there are different standards. I need to know what exactly and what for what exact reason they want to do that. So I have to comply and I have to test within those criteria.
Yes, coming to the point. Turbo Energy Limited purchased steel from your company and you sold them the steel which contains 13% chromium, didn't you?
13% chromium for that particular purpose, which was necessary for that particular purpose.
Okay, so you have mentioned in the report that you have tested the metals. Do you know that the standard percentage of chromium in steels which are used in water turbines?
As I mentioned you earlier, you can check researchers from Harvard universities, the departments of metal, and also MITs. There are different standards, and the standard which we chose, we have done this for the past 10 years, and it has been accepted. So we will say, and I will say over here, yes, it was adequate and it was correct.
So you must know the standard percentage of chromium in hydro turbine, and still you agreed to supply the steel which contains the chromium of 13%, whereas the standard quality of austenitic steel is 18 to 25%. The minimum standard is 18 and the maximum is 25%. What do you want to say on that?
Honorable Counsel, there are a lot of reports which suggest that the minimum criteria are more than 30%. It depends upon which opinion you proceed to. But the most accepted is that it should be at least above 12% and below 18%, because there is cost management issues. Okay, you just cannot indulge on chromiums as much as you want. And that's why I'm saying clearly that there are a lot of opinions, difference of opinions, but the most accepted in terms of business transactions, in terms of within the scientific community, it's that it should be above 12% and below 18%. And our one was 13.8%. And we have done this for a very long time.
That's all, Mr. Norman. Thank you.
Thank you. Counsel for the respondent, do you have any other witnesses? Counsel for the respondent? I take it you don't have any more witnesses?
No, no, Honorable Arbitrator, we do not have any other witnesses.
Okay, so this closes the evidence part of the proceedings, and we can now move on to the closing statements. May I now invite the counsel for the claimant to submit closing arguments?
Thank you, Honorable Arbitrator. First of all, let us consider that there has been a lot of facts that has been stipulated throughout the hearing of this case, which we as the claimant believe all come in our favor, and we will show it how. So let us consider the fact that first that the respondents have had the report of the steel, which clearly stated the chromium percentage, and they were confident about the quality of their steel. However, the point to be noted here is when our client express their concern to their chief negotiator, the easiest way to deal with this particular scenario would have easily been, and I would sure my peers would all agree, and Roger would agree that showing this particular fact and showing that they're confident about this steel and this is premium and they know that these are the percentages of each component present would be the easiest way to dispel our concerns. However, when Mr. Binod Kumar, the CEO of the respondent, had made no such claim like that, did not present us with a report. Furthermore, the reason we had concern, the reason our client had concerns was because of the report released on good quality steel, which is one of the major suppliers of our respondents. So the fact that they did not use good quality steel, they used steel from Salsabille. That particular fact was not even mentioned in any of the email correspondence to us, which would have, if not totally dispelled our concerns, would have significantly decreased our concerns, as would for any rational human being. Now, let us get on to the fact that the council has tried to make our report that we did totally obsolete. It is unfathomable to me to understand that how does a company who does international business not know of the organization Brooker, which is an international organization solely for the purpose of metallurgic and chemical property testing for metals. And they were asking for a date. Honorable Arbitrator, Brooker uses an XRF PMI gun, which gives the metallurgic test for metals on the spot. They come. So what we did was call them to our power plant, had them do it, and give us a report on the exact same date, which is why the mention of a date on the report was not necessary. Furthermore, now let us go to as the claimants have mentioned that we are too consumed about the chromium percentage. Now, why is that? Let me first give you explain why. And it is a well-known fact and can be asked to any scientist, they will confirm to this that it is chromium element in the metal that gives the steel alloy its water resistibility quality. That depending on the amount, the more how does it do it? What it does is reacts with the water, creating hard surface layer and preventing the water from reacting with the iron and corroding it, which is the primary component of any steel alloy. So, and furthermore, internationally set criteria for austenitic steel. We are not saying that that is the only steel available, which seems to be the notion of respondents. They seem to be thinking that we are on the notion that it is only 18 to 25% of chromium availability in steel that can be called good steel. Honorable Arbitrator, apologies, but I couldn't understand what you said. The audio was a bit.
Sorry. Okay. Yeah, I can hear you. Please go ahead.
Continue. Oh, thank you. So as I was saying, the respondents seem to be under the notion that we are just saying that it is only 18 to 25% chromium present that it can be called premium quality steel. No, we are not stating that. Premium quality steel can start from 12% of chromium. However, the point we're trying to make is in the case of water turbines, which is constantly in contact with water and totally motion enriched in water, the corrosion rate is higher than normal circumstances, which is why the austenitic steel, it is only the austenitic stainless steel that is used in water turbines internationally. And for it to qualify as austenitic stainless steel, the chromium percentage to be present, there needs to be a minimum of 18%. and highest would be 25%. Now, they are obviously trying to make our reports obsolete. We will not consider then, which is outrageous because we have done it with a certified international organization. However, let us not consider the condition in our report, which says the chromium percent is lower. Let's consider their own report, which says it is 13.68%. Honorable Charlie, it honestly scared me again when crossing Mr. Binod Kumar and my co-counsel cross Mr. Minazur Rahman. The fact that they did not even know the idea of austenitic steel totally scared me, and made me question how were they in business in the first place at all in regards of water turbines. And the fact that they did not know seemed quite fishy, considering they have been doing work for 20 years. So that tells you a lot of whether they were actually did not know, or were they knowing of it and still did not care. Further, but let's not dwell on this too much. So considering the fact that they themselves are admitting that yes, the chromium present was 13.8%, which in their exhibits they proved, how can they say that they meet international standards? And they, in their own chief examination, said the minimum is 12 and the limit is 18%. All right, fine. Even if we are to consider that to be true, which is totally outrageous and not true at all, the fact that they promoted us, the turbines, as premium quality, state of the art, best in the world, how can they say that their resistivity to water, corrosion resistivity to water is best in the world when the limit they themselves said, which is not true, but they themselves said, and the percentage present in the report is already deviated significantly. They said the limit is 18%, but there only contains 13.8. So how is it that they're claiming that their R27V Francis turbines was state of the art as they have described? Which brings me to my point. Which brings me to my point of the legal facts of this issue, which is Section 15 of this Sales of Goods Act 1930, which says that the sale of the goods shall comply with its description. According to its description, it's highly water resistant, and if highly water resistant. Now, considering the reports, we have also shown as our exhibits in Riverdale, which is 11.2%, and as our report, which is totally credible, shows 11.5%. How are we to know that this complies with the description when it does, when the two conditions are so similar? And the reason we had the concern in the first place was because of the shutdown of the Riverdale power plant. Furthermore, the implied condition of the quality of goods, one of the implied conditions, which was also stated in the preamble, also as to the purpose of the goods, was that one of the main considerations, which is why even our client got the tender in the first place, was that the maintenance periods needed to be short and the maintenance intervals needed to be longer. The fact that the metallurgic composition complies with the metallurgic composition in Riverdale power plant so closely, obviously is a factor. Evidence can act as an evidence that this can no way last that long, as they have also said in their in the Article 2 of the sales agreement, which was got into with our client and the respondent, that to provide during the anticipated 40 years lifetime. They said that our turbines were anticipated to last for 40 years. Whereas considering the fact that they're so similar to Riverdale, they had to shut down in 2 years. Even in the best case scenario, we would only get a year more, which would not be viable for us in any way. Furthermore,
1 minute left.
Furthermore, so for such reasons, the damages we are claiming that we claim are that for the 29 days that the power plant was shut down, for which we are having to pay 40 lakhs per day for the unavailability of power, which is also a fact in the agreed upon facts. We seek that the claimant pay us as a consequential loss. And furthermore, we urge the court to make the respondents replace our turbines immediately, as considering the fact that they knew that only 13.8% of chromium was present, and they still made those steel with for using that steel and not using austenitic steel at all, shows that they did business with that malified. And for such reasons, we urge the court that we need the replacement as an actual loss. Furthermore, Section 73 of the Contract Act states that we are entitled to damages if the damage is foreseeable. Honorable arbitrator, it can easily be seen that considering the fact that the chromium percentage in the stainless steel are so low, it is foreseeable to any steel manufacturers or any business involved in this industry that the low level of chromium, because of the low level of chromium, the foreseeability of corrosion and cavitation is easily foreseeable. And the Green City, which the main reason why they shut it down is because they do not want to harm their people. Because of corrosion from metals, when it enters the water stream, it can highly contaminate the water stream. And the only sustainable livelihood in Green City is farming. And if the water stream is contaminated, their livelihood will be halted, and their lives will come to a standstill, which Mr. Lawson was the primary objective of halting, and which is why we believe we do deserve and strongly urge the honorable arbitrator to have the respondents replace those turbines, and also pay or give us a compensation of 40 crores total, which is 20 crores plus interest of 2.5%, which comes to a total of 41 crores. And additionally, an 11 crores, 29 lakhs for the days that power plant had shut down, we had to pay the penalty, also with an interest, which comes to a total of 11 crores, 89 lakhs.
Thank you, counsel.
Thank you.
May I request the counsel for the respondent to submit your closing arguments?
Yes, Honorable Arbitrator. I will be answering to the propositions given by the claimant, and also I will be then seeking my reliefs, and that will be my closing statement. All right. The first issue which the claimant brought up was that why didn't we inform our claimant about the supplier from whom we will be taking the metals? In terms of our sales agreement, nowhere it was written that it was supposed to be informed to them. It is our subject matter of the case that from where we take. The main issue of the sales agreement is that if the metals go on with the criteria that the claimants are looking for, then they will accept it, which they very properly did. So it doesn't matter from where we took it, but for the sake of the arbitration, we had to bring it because they were claiming that we took it from somewhere which is not applicable to the requirements given. Now, the second issue which the claimant was proposing is that about the issue of negligence. I believe it was about the issue of negligence that we did not respond to them properly. Our negotiator did not conduct with necessary notions. But as even their evidence suggests, and also what we said previously in our opening statements, that we continuously discussed with them, we continuously responded to their queries. We went over them when we told them that we will be inspecting them, because right now there is no objective problem. The claimant nowhere said that there is a proven corrosion which is available. Rather, it is an anticipation, which I will discuss later on, and what we mean by anticipation and when it comes to these types of companies. Regarding the issue of fake reports from the Bruker, of course, Bruker is an internationally recognized institute when it comes to metallurgy testing. We did not deny that. What we denied, what we implied was that, what we explicitly said is that we are not sure when this report was conducted because there are no dates. We are questioning the validity of those tests. We did not question the authority of Bruker, which the claimant was very highly proposing, rather than answering the questions of date, which we very easily asked, which was simple answer to give. Regarding our next issue, which was the very big issue, which I think the respondents, the claimants are not clearly understanding, is that we did not deny their standards. We accepted. We said that yes, it is available. But what we are saying is that there are difference of opinions, even when it comes to water turbines. Maybe the claimant is not aware about it. We did not say that that is the only objective criteria which we are following. There are difference of opinions, but when it comes to the best efficient cost management, and when it comes to the best way to propose any materials, the best would be that it should be above 12% and below 18%. And that is what we are doing, and that is what we did in the past. And that is why this metal is still not corroded. It is still not cavitated. Rather, this is nothing but an anticipation due to some other reports given. Now, the second issue about the international standards and the national standards, and the claimant suggested that we showed our image on a level of international standards and national standards. Yes, we did, but the transaction between us and the claimants are a national one. It is not an international one. And nationally, the standards which we followed are very much accepted. That's why our claimant did not dwell upon that agreement. They are supposed to follow international standards. As I mentioned earlier, there are a lot of difference of opinions, which I think the claimant aren't aware about. When it comes to international transactions and international standards of tests, there are difference of opinions. When it comes to national, there are again difference of opinions. But the transaction which we had between the claimants were a national one, and we followed the national standards, which was above 12% and below 18%. Now, the second issue, the next issue is about the Article 18 of the sales agreement, which was clearly written that it was the buyer's obligation to perform acceptance test. And then after the acceptance test, then they would pay us the rest of the installment money. So this means that if they passes the acceptance test according to their standards, then they will pay us and our products are good. And this is what actually happened. And even as per the facts, it's clearly written that they started the operation of the turbines. So again, going back to that issue that we are not in a breach of contract. And when it comes to the issue of anticipation of breach of contract, there should be some necessary documents or some necessary evidences which suggests that there will be an anticipatory breach. But as we discussed, that nowhere did the claimant objectively prove that there are traces of corrosion, there are traces of problem in our turbines. So we are not in breach of contract, for which they are highly charging us with. Now, the last issue, which was about the guarantee of 40 years, and that is the whole issue over here. Our product is still not corroded and still not cavitated, and we are still giving the guarantee that it will work for 40 years. But for our duty of act and for the good faith of the business, we decided that we will inspect it, because they are claiming that there might be a problem due to some other evidences from the news reports and some questionable documents brought up by them in this arbitration. So we already suggested that we will be inspecting it. If there is an inspection, then we can have a different discussion on how that will be resolved. But before the inspection, we cannot say anything. And the reason why we are saying that we want to inspect is because there are no objective reasons to believe that there will be a corrosion or there is any corrosion. Finally, Honorable Tribunal, I will be seeking for the remedies. In light of all the facts and arguments mentioned earlier, we, the respondents party, seek from the tribunal the following declarations. Number one, declare that the respondent did not breach the contract. Number two, declare that the anticipation of breach of agreement proposed by the claimant has no objective grounds or rationale to believe in. Point number three, declare that the documents presented by the claimant in regards to the quality of the metal used in the turbines cannot be taken into consideration due to their fallacies. Number four, declare that the respondent abided by all the obligations stated in the sales agreement. Number five, declare that the respondent is not the accountable party at all and should not be subject to such claims. Number six, declare that the claimant party is one to be accounted and for due to their obligation of running the independent acceptance test stated in the Article 18 of the sales agreement and without any complaints starting the operation of the power plant. Number seven, declare that the respondent is not negligent and did not perform any unfair activities. If the Honorable Tribunal do not have any further questions, I would like to rest my case.
Thank you, Counsel, for the respondent. This would formally conclude the hearing. If parties need to submit any post-hearing briefs, you should consult amongst yourselves and let me know. And of course, within 2 weeks, please submit your cost submissions as well. With that, I would formally close the hearing. Thank you very much.
Arbitrator, could we be allowed to give a rebuttal to that closing statement?
No, I understand there is no such provision in the current program. Yeah, and I think we fall in the deadline as well. Generally speaking, you don't really get that chance. Of course, it's within the tribunal's discretion, but usually the closing arguments is the last phase when the respondent submits their arguments. And that usually happens in briefs.
Okay. Thank you, Honorable Arbitrator.
Thank you, Honorable Arbitrator and all the participants. Now I would like to request all the participants and our arbitrator to turn on their video for capturing a group photo.
Sorry for the delay, ma'am. If we just give 2 minutes to our team, they're turning on the camera. Thank you, ma'am. We're all here, ma'am.
Okay, done. Thank you. Dear all, now it will take 5 to 7 minutes to prepare our result. During this period, we will watch a video on introducing BIAC. Dear all, we need few more minutes to announce our result. We can take a short break for 5 minutes. Please do not sign out from the session, but you can keep the video and audio turned off. Thank you.
Hello, everybody. I have just completed the score sheet and I'm ready to announce the results, if I may. Priyanka?
Yes, sir.
So do I give my comments after announcing the result, or do I give my comments first and then announce the result? People
Yes.
might lose interest in my comments once they hear the result.
No, I think you can give your comments first and then announce the result.
Okay, sure. So yeah, it was a pleasure participating in today's session. Thank you all for your participation. Everybody did a fantastic job. So I will give some general comments. I don't like to single people out. But some of the things which I noticed, especially from the respondent side, I think especially I'll start with the cross-examination. So one of the counsels for the respondent, I mean, you cannot make statements in a cross-examination. You're the lawyer, you're cross-examining the witnesses, you're trying to elicit answers of the witness. You don't make sweeping statements, or you don't come up with a case theory or a principle or a law. You're trying to extract some information in a certain way that undermines the credibility of the witness, right? So I noticed that one of the counsels was struggling with that. So I think one of the rules, or one of the things that I've learned is that your style has to be very conversational. It has to be very confrontational, because I noticed that a lot of the people acting as witnesses, they were getting carried away too, with all the information, which is fine. It's a mock arbitration, but end of the day, your style should be very conversational. It's as if, not that you're talking to a friend, that's somebody you know, because it's almost like you have to set up a trap for the witness to walk. If you're very confrontational from the outset, everybody's watched A Few Good Men. Everybody gets fascinated by how Tom Cruise cross-examines Jack Nicholson and all that. We dig that. We like that. A lot of lawyers become lawyers to cross-examine witnesses. Everybody gets that high. But bottom line is, you need to accomplish a certain objective. And for that, your style has to be conversational, very casual. You don't have to be very aggressive. And in that, while doing that, what will happen is the witness will usually let his or her guard down. And that's when you make the opening, you go in and you get some information from that witness that will help your case. Okay. So I think the style was conversational, but again, you have to ask questions. You don't make statements, right? And also, I think one thing, this is a general comment. Again, I think one of the issues I noticed was there didn't seem to be very clear case theory, right? So what is your case about? What is, if you filed a claim, what is that basis? I know what the player is, what the relief you're seeking, but there has to be an overarching case theory, right? Or case theory is what? So let's say if I'm for the respondent, I'm saying, okay, is my job or my strongest case basically built on the basis of an argument that we were not responsible at all? You know, it was an absolute liability issue and we don't have any liability at all. It was an absolute liability or responsibility of the claimant, or the third party, right? So you have to be very clear about that, and everything essentially follows from that. So I didn't see that clarity. It seemed like you were looking for 2-3 different issues or grounds, which is fine, but there has to be a connection between them as well. I couldn't quite figure out. So what are you trying to get at? We don't have any liability, or our liability responsibility was only to the extent of responding to emails, being very responsive. Our responsibility was to make sure nothing wrong happened, or if something wrong happened, you know, to what extent are we liable? Something like that, right? So there has to be that clarity as well. That holds true for both the claimants and respondents. Yeah, in terms of presentation, I think overall, I like both the closing statements, very well done, both of the counsels. And one of the, so what happens in real arbitration is, you know, examination in chief, which I would suggest to BIAC as well, don't spend too much time on it. Devote more time to cross-examination, because in a real arbitration, there is frankly no real examination in chief. All that happens is an introduction of the witness done by the counsel, and that's about it. So it's a very court-specific procedure that, you know, you have to basically have a detailed examination in chief. So I think for BIAC2 for the contest, if you really want to build a real skill, don't focus on examination in chief, focus on cross-examination. So about that, you know, you just do the introduction and you just proceed with the cross-examination. And yeah, so one of the things you do in the closing statement is, as one of the counsels did as well, you basically summarize your arguments, but it has to be very spontaneous, so to speak. So you can't really prepare your closing statements when you go inside the hearing. You actually prepare it during the course of the hearing. And a lot of the focus of the closing statements is the evidence presented during the course of the hearing. You basically try to convince the tribunal that in light of the evidence presented, documentary, of course, there's no documentary during the hearing, the testimonies, the cross-examination, oral evidence submitted, this reaffirms our position or confirms, you know, what we've been arguing all along. So the primary focus of the closing statement is the evidence. So you essentially can sort of clean up some damage that's done by your witness. You can counteract some of the claims made by a witness that you could not address in cross-examination, something like that. But that's your primary focus. Other than that, yeah, I think yeah, you complied or adhered to the timelines as well. There was no sort of overstepping that line, and yeah, yeah, interruptions, to try to minimize those interruptions. Let sort of a certain phase complete, and then you can do it. Of course, you can do it at any time, but of course you have to seek the permission of the tribunal. But I think generally tribunals don't really like those interruptions. They have a certain expectation of the proceeding, so you just, you know, stick with that. Yeah, I think that's about it. I basically asked 1 or 2 questions each of the counsels, and I think in both cases they weren't satisfactorily answered. And I think which sort of speaks to the point I raised earlier, which was that there was no clarity as to what the case theory is. Are we shifting responsibility to the third party, or are we actually confirming that, you know, we did our part, we didn't breach the contract, we fulfilled all our duties? So I think that should be addressed first, and don't come up with evasive answers. Not the judge, not the nobody likes that. You know, you will be doing a lot of litigation as well. But the last thing you want to do to a judge or an arbitrator is not answer their question. If you don't know the answer, just say, Honorable Tribunal, Court, please give me some time to respond to this. But don't be creative with your answers. That makes things worse. If you don't know the answer, right off the bat, just say, I need more time to answer your questions. Please allow me some time. Okay. So I think, yeah, that's about it. Overall, good job. I think this is a fantastic initiative. I can actually BIAC once again. I thank them once again for this opportunity, for having me here. I think because what you're doing is you're sort of sowing the seeds of you know, all this up and coming arbitration laws, because of course it's a growing field. It's a very exciting field. We need a lot of people. I'm a big proponent, advocate of people coming from South Asia, you know, doing big things, because you know, let's face it, it's heavily dominated by people in the West. it's about time we sort of step up to the plate and do it. And I don't think we lack in skills in terms of, we're very articulate, eloquent, lawyers, students, and frankly, international arbitration is not rocket science. So you guys have the skills, and I think this is a great springboard for you to sort of launch from here and build on it. So thank you once again. And with that, of course, there's always a winner, and one school that does not win, I don't call them the loser. But we're all winners here. One school did better than the other, and of course, we need to announce that winner. And today's winner is the claimant, Bhuyan Academy, Bangladesh. So I congratulate you for doing a very good job. And I commiserate with the North South University. Again, my comments are again meant to improve your skills, and hopefully you can do a better job next time. So thank you once again. I wish you all the best.
Thank you, sir.
Thank you, sir. Congratulations to the team of Bhuyan Academy, and thank you to the team of North South University, Bangladesh. You guys did a very good job. Better luck next time. Now, I would like to conclude the session by thanking the arbitrator of today's session, Mr. Rana Sajjad, and team members of both the universities, along with their faculty members who worked hard to train up and prepare their students for this contest. Thank you all for joining us online.
Thank you. All the best. Bye-bye.
Thank you.
Thank you, sir.
Thank you, sir. Thank you, ma'am.